Arthur Garza, and I'm the Vice President of AMHO. And before we begin, I have a mandatory disclosure. This meeting is a private forum created specifically for manufactured home park tenants and allies. This space is not intended for park owners, park management, or their legal representatives. If you are here in a park owner or representative capacity, we ask that you disconnect now. This is a resident-only space designed for the private discussion of our community goals and advocacy.
All righty. Well, good evening, everyone, and thank you so much for joining us tonight. Before we begin, a quick reminder that this Zoom session is being recorded and is to be posted on our website. To help keep the audio clear for everyone, please remain muted throughout the presentation. For those who may be new to us tonight, the mission of the Association of Manufactured Home Owners, AMHO, is to promote, represent, protect, and enhance the rights and interests of manufactured home owners in the state of Washington through communication, education, negotiation, and preservation of our communities. We want to make sure your questions are captured. Please direct all of your questions in the chat to Bill Hardy. In chat, you will see Start a New Chat and add only Bill Hardy. We will answer as many of those questions at the end of the presentation as time allows. If you would like to direct feedback or follow up after tonight's meeting, please feel free to leave your email address in the chat along with your question and a request for contact. And now it's my pleasure to hand things over to Director Michael Rohlf, sorry, Michael, who will present our workshop on navigating RCW 59.20. Michael, the floor is yours.
Thank you, Deb, and welcome everyone. Thank you for joining us today. Today's workshop focuses on our rights as manufactured home residents under Washington state law, specifically the Manufactured Mobile Home Landlord-Tenant Act, or RCW 59.20. Before we jump into the material, please keep in mind, I am an advocate and fellow resident, not an attorney. And this presentation is for educational purposes to help us organize and advocate effectively. To keep things running smoothly, we will answer as many questions as time allows at the end of the presentation. Remember to submit those questions directly to Bill in the chat portion of the Zoom call. As the presentation begins, if you double-click on the slide, it will go to a full screen for easier viewing. Here's an overview of what we'll be covering. 6 modules that explain in-depth portions of the MHLTA that we find to be some of the most common areas of abuse by landlords. Let's start with Module 1. Module 1 is the Evergreen lease and the expiration myth. Let's talk about the expiration myth. Many of us get a notice in the mail or a knock on the door saying, hey, your lease is up on the 31st. Please come into the office right away to sign your new contract. They really make it sound like you have to sign that contract or that it is a standard necessary procedure. This creates a lot of stress on the homeowner. You don't necessarily want to sign a contract that's different from the one you signed before. And you know it only benefits the manager. And then managers often make it sound like if you don't sign, you'll be evicted or you'll lose your spot. I want everyone in this room to hear this clearly. You are never required to sign a new lease. Not ever. Why? Because of what Washington state law explicitly mandates in RCW 59.20 59.20, Section 1. It reads, unless otherwise agreed, rental agreements shall be for a term of 1 year. Any rental agreement of whatever duration shall be automatically renewed for the term of the original rental agreement unless a different specified term is agreed upon. That means agreed by both parties, not just a manager says that, well, this is the change and it took effect. This is why we call your lease evergreen. It does not die. When the calendar year ends, it automatically resets on the exact same terms. Think of it like a relay runner just taking another lap around the track. Unless you give written notice that you are leaving, or the landlord has legal just cause under RCW 59.20.080 to terminate the tenancy, your contract automatically renews for another full year. This protection was firmly upheld by the Washington State Supreme Court in the case Western Plaza v. Thyssen. The Supreme Court ruled that under the MHLTA, unless both parties explicitly agree in writing to change terms, every single portion of your original lease automatically renews annually on your renewal date. The court recognized that because you own a physical home sitting on rented land, you cannot easily pick up and move. Sometimes legally you can't move. So the law protects your long-term stability by preventing landlords from forcing new lease contracts or stripping away your rights. No matter how much pressure management applies, you can simply say no to signing a new lease, and your existing original agreement legally remains in full force. Now, are there any exemptions where a landlord can change upon renewal without you signing a contract? Yes, but only 2 specific statutory exceptions exist. 1, lawful rent increases. RCW 59.20.090, Section 2, and RCW 59.20.370 state a landlord can raise your rent upon renewal, but they must provide you with written notice of at least 3 months, that's 90 days, prior to the effective date of the increase. And that must be 90 days prior to the end of your lease term. Furthermore, under new state law, rent increases are capped at 5% within any 12-month period. But no increase can occur in the first 12 months of tenancy, and they can never happen in the middle of your 12-month term. They can only take effect at your annual renewal date. Number 2, bundling utilities. RCW 59.20.060. Under RCW 59.20.060, Section 1J, a landlord can decide to stop including a utility in your base rent and start billing it separately. However, under RCW 59.20.060, Section 2C, if the landlord unbundles a utility previously included in your base rent, they are legally required to give you a pro rata reduction in your base rent equal to the amount previously allocated for that utility. They cannot simply strip the utility out and force you to pay the same amount you were paying and a new utility charge. That's paying double. Bottom line, unless the landlord is implementing a rent increase with a full 3-month written notice or unbundling a utility with a matching base rent reduction, they cannot unilaterally alter your agreement. You do not have to sign a new lease. Module 2, utilities and the no markup rule. Utilities are often where we see the most hidden rent increases. Under RCW 59.20.070, Section 6, a landlord is strictly forbidden from charging you more than the actual utility cost. What does actual cost mean? The landmark court case, Rainier Vista, settled this clearly. Actual cost means the exact dollar amount on the bill from the city or utility provider. If the municipality charges a park $1,000 for sewer services, the landlord can only collect $1,000 total for the entire resident community. Not a penny more. Not for administrative fees, billing charges, or convenience charges. How parks bill you? Sub-metered versus pro rata allocation. Most manufactured home parks do not have individual city or municipality water utility meters at each home. Instead, the utility company sends the park one master bill. When this happens, how is the landlord allowed to pass through charges to you? Landlords generally use one of two methods to split that master bill. Number one, sub-metered billing. The park owner's private sub-meters at each site measure individual usage. The landlord reads these meters and bills each resident based on their exact portion of the master bill. Or two, more commonly, pro rata allocation, or equal splitting. If the park has no individual meters, the landlord is legally permitted to divide the total master bill proportionately, such as by square footage or an equal split among occupied lots. That's the most common that anybody who is hooked to a city or county municipality at a park is charged by their landlords. The pass-through law, regardless of whether your park uses sub-meters or pro rata splitting, the sum of what all residents pay cannot exceed the exact amount on the master bill. The landlord is simply a pass-through entity. They cannot make a profit on the utility billing. Well and septic systems, the zero utility rule. This pass-through principle is especially vital for communities on private well or septic systems. If a park owns its own well or septic infrastructure, it is not receiving an external water or sewer bill from a city or public utility district. Therefore, the actual utility cost passed through to residents can only be $0. Landlords often try to tack on a $50 water sewer fee to cover pump replacement, water testing, or routine maintenance. Under the Manufactured Mobile Home Landlord-Tenant Act, MHLTA, those are standard operating capital expenses. Operating expenses must be built into the base rent. They cannot legally be unbundled and charged as a separate utility fee if no external bill exists. Bottom line, if there is no external utility bill, there is no utility charge. Module 3, maintenance, the permanent structure shield. Who is responsible when a park-owned storage shed starts rotting? A tree branch overhangs a roadway, or the clubhouse roof leaks? RCW 59.20.135 is explicit. A landlord cannot transfer the maintenance responsibility of permanent structures to tenants. Permanent structures include common facilities, clubhouses, park-owned carports, roads, and storage sheds that were provided as park amenities. Even if your lease contains a clause stating tenants responsible for maintenance of a carport, that clause is legally void under RCW 59.20.045, Section 4, because it attempts to evade a duty assigned expressly to the landlord. Under RCW 59.20.130, the landlord is legally obligated to keep common areas safe, maintain roads, and keep all utility infrastructure in good working order up to your home's individual hookup point. That means up to where your home's pipes meet the ground is their responsibility. You are responsible for your own mobile home and routine upkeep of the rented lot space, not the pipes beneath it, just the space itself. But if a landlord tries to pass off main water line repairs, tree removal on common land, or clubhouse repairs to residents, that is an illegal shift of statutory duty. Module 4, rule changes and the 6-part enforceability test. Landlords often try to alter park rules mid-tenancy to cut costs or dictate lifestyle choices, such as what color your house can be. But here's the most important rule of thumb. A park rule is not automatically valid just because management printed it. Under RCW 59.20.045, for any park rule to be legally enforceable, it must pass a 6-part statutory test. If a rule fails even one of these standards, it is legally invalid and considered unenforceable. Number 1, legitimate purpose. The rule's purpose must be to promote resident health, safety, or welfare, to preserve the park from abusive use, or fairly distribute shared amenities. It cannot exist merely for management's personal preference or financial gain. Number 2, reasonable connection. The rule must be logically and reasonably related to achieving that health or safety goal. 3, fair application. The rule must apply to all tenants equally. Management cannot single out individual residents. Number 4, no evading duties. The rule cannot be created to dodge a landlord's duty, such as forcing tenants to maintain park infrastructure or common grounds. Number 5, no retaliation or discrimination. The rule cannot be used to target active residents, that's you or me organizing in a fashion to protect ourselves, or discriminate against specific groups. Number 6, 30-day written notice. For any new or amended rule, the landlord must provide a full 30 days written notice. Pay close attention to this compliance timeline. Under RCW 59.20.045, Section 6, once that 30-day notice period ends, the law grants you a mandatory 3-month grace period to comply with any new rule. During those 3 months, any alleged violation can only result in a written warning. The landlord cannot issue an eviction notice or terminate your tenancy during this period. Altogether, you have a 4-month window from the day you receive notice to organize with your neighbors, send a rule dispute letter, or seek legal aid before tenancy is ever at risk. And remember, under RCW 59.20.080, Section 1A, even after the grace period, an eviction action can only occur if there is a substantial violation of an actually enforceable rule. Module 5, proper delivery of notice. Now that we've covered your substantive rights under the law, we need to address execution. How do you actually deliver a notice to the landlord, and how must they deliver a notice to you? Landlords sometimes leave an informal note, send a quick text, or post a notice on a door and claim it's binding legal demand. Under Washington law, informal delivery does not meet statutory standards for notice. Under RCW 59.20.040, formal notices served by a landlord must strictly follow the service methods in RCW 59.20.150. There are only 2 methods of service. 1, personal delivery, handing a copy directly to you in person. And 2, posting and mailing. Affixing a copy in a conspicuous place on the home, like your front door, and mailing a second copy via U.S. mail to your last known address. This is key. They must do both. Affix it to your house in a conspicuous place and mail it to you. They cannot just put it on your home and call it notice. Text messages, phone calls, or mass flyers left in common areas do not constitute legal service on a tenant. How this applies to you and how you serve notice on a landlord. When you send a notice to repair under RCW 59.20.200 or a rule dispute or any other form of notice, these are formal legal notices that need to be served under the statute. Some of them start a mandatory repair clock. Therefore, you must establish verifiable proof of delivery under RCW 59.20.150, Section 2. Best practices for this: number 1, certified mail. Send your notice via certified mail with return receipt requested to the address provided in your rental agreement. The postal tracking signature serves as a verified document for court evidence. Best practice number 2, hand deliver with a witness. If you deliver it to the office in person, bring 2 copies and ask staff to sign and date yours as received. If they refuse to sign, make sure you have a reliable adult witness with you. Your witness can complete a declaration of service under penalty of perjury per RCW 5.50. This details the date, time, and the staff member present when you served mail with your witness. What about email? Under RCW 59.20.150, Section 2, sending a notice to the landlord by email is legally valid only if the landlord has expressly agreed in writing to receive official notices by email. If you do not have that written agreement in your lease or a signed addendum to that effect, do not rely on email alone. You can send an email also, but always use certified mail or hand delivery so your statutory timeline under RCW 59.20.200 legally begins, and you can ensure you can show verifiable documentation to a court if need be. Module 6, the retaliation shield. So now that you know how to enforce your rights and properly serve a notice to repair or rule dispute or any other notice that you may serve to the landlord, I know many residents have one big fear remaining. If I send this formal notice, won't management target me or try to evict me? This is why RCW 59.20.075 is your legal shield. RCW 59.20.075 establishes a 120-day legal presumption of retaliation. If you engage in a good faith assertion of your rights, such as serving a written notice for repair or any other kind of written notice, filing a complaint with the Attorney General, organizing a residents association, or disputing an illegal rule, and the landlord attempts to, say, increase your rent, decrease your services, harasses you, or issues an eviction notice within the next 120 days, the law presumes the landlord is retaliating. In court or administrative proceedings, the legal burden shifts entirely to the landlord to prove they had a legitimate, non-retaliatory reason for their action. This statutory shield exists specifically so residents can stand up there for their rights without fear. Again, the law assumes the landlord is retaliating during that time period, and it is up to the landlord to prove that they were not retaliating. In the end, you don't need to be an attorney to advocate for your home and your community. You just need to understand the statutory standards and put your communications in writing. Right now, we are working to add on the AMHO website a few downloadable letter templates that you can use when addressing some of these issues we've covered. They will reference the exact RCWs we reviewed today. When landlords receive a formal document that cites a proper RCW, such as 59.20.200 or RCW 59.20.045, they know you are documenting the record accurately. They know that you've done your homework and that you have protection that you know about. You understand your rights, and you're showing them that you do when you use a letter that correctly cites RCWs that they are violating. I want to thank everybody for their time today. Thanks for you listening to me go through this script of information. And at this time, I want to open the floor to the general questions that Bill has been collecting during this time that you've been listening to me. Bill, let's move on to the first question.
Well, I guess the best thing for me to say is that right now, there's no questions have come through in the chat. So if somebody's got a question, they should get it into the chat, send it to me, or just send it to everyone. And I think you did one excellent job of explaining everything. And I'm very impressed with all the knowledge that you've conveyed in this last half hour.
Well, I appreciate that, Bill, and also know that this is the reason we're recording it as well. So if somebody missed anything at all, they can go back and re-review this on our website here once we cut it and edit it nicely, and we'll post it there so everybody can find it again if they want to listen again or reference.
Okay, I have a question that has just come in.
Great.
Can a landlord force us to sign a new lease when there is a new tenant?
So the answer to that is you're saying, I guess, if someone purchased a home, if they purchased a home and assumed the lease from the last tenant, the answer is no. You have assumed the lease, and that lease will roll over automatically every year thereafter, and that is now your lease. If a tenant moves in or say moves on a new manufactured home to say a vacant lot and is starting a new lease, that would be, the answer would be yes. They would have to sign a lease. In fact, the owners themselves would be required to offer a lease before you ever even touch down with that new manufactured home onto a lot.
Very good. I'm looking for any other questions at this point. Use the chat if you have one. That was an excellent question.
Absolutely. So just so everybody knows, chat is the easiest way to have you put these questions through to us. If we opened up all the microphones, it really just wreaks havoc on being able to record this and have it be a session for people to reference later.
Yeah, we've got more than 24 people on the meeting tonight, and I hope they're all getting good things. Oh, okay. The clarification from the person who just asked the question is previous lease, new tenant. So let's clarify that.
So previous lease, new tenant, meaning that they have assumed the lease of the prior occupant. And the answer there is you have assumed the lease, and that lease stands as it was when you assumed it. So if you assumed it and there was, say, 3 months left on its term, your lease would automatically renew for another term at that renewal date. And no, you don't need to sign another lease with them. They can hem and haw and squirm and whatever they want to do, but you have legally assumed a lease, and now that lease is yours.
Okay, new question. Do the RCWs cited, and that's the Revised Code of Washington, which is state law, do the RCWs cited pertain to a homeowners association or to individual tenants only?
Which are we referring to them citing?
Yeah, go ahead and clarify on that one, the person that sent it in.
First, let me say that a homeowners association is not the same thing as like a tenants association that you might form to take care of the people in your park. And you are not allowed to file a complaint regarding any RCW as a whole association. Everyone needs to file their own complaint form to the Attorney General. So you can't, like, say our tenants association is complaining about sheds being in bad condition or whatever. You can't just do that. So the RCW, I guess, in that respect is for each individual inside a park. That's how I'm reading that. I don't know about you, Michael.
Yeah, if that's what they're talking about, most definitely. And you guys are lucky you got Deb here. She's done a lot of work in the protection association group arena and has done this where they have all the residents pretty much have the same complaint, right? And you'd love to do one complaint with everybody's name on it, but the way the law is structured and works is that you do need to do an individual complaint with a separate name on each one. However, each of those complaints could be identical in their reading and in their nature.
Okay, the person who asked about the difference between the homeowners association and their individual tenants is saying, I am asking in specific requests to correct repairs on maintenance, watering, and mowing.
Yeah, so it would apply to exactly what we were talking about. You wouldn't you would want to band together in your association to show that you are on a united front, but you would want to do an individual complaint per home that's being affected and have that person's name on that individual complaint. You could serve them all at once. You can, if it escalates to a dispute resolution uh, complaint with the Attorney General's office, you can send those all at once to the Attorney General, but they do have to be signed individually and have a name from each tenant and their lot number. That's how you would do that. Again, you could do it in mass, and every letter can say the exact same thing, but they do need to be signed and indicate each individual person.
Okay, I've got some more questions that have come in. If the rules change regarding fence heights, do old fences have to comply to the new rule?
Yeah, so I would go back to that enforceability test. Why are they changing the rule? What is the rule doing? Is the rule for the health, safety, and welfare of the residents? Does it prevent the park itself from being uh, abused? I mean, in my mind, telling you the height of your fence needs to change and making that a rule is most definitely a challengeable rule. I don't see how that meets all of those six standards, or even the first standard, right, as an enforceable rule. So I would challenge the entire rule.
They did that in our park and said that I think it's 4 feet and it has to be chain link, but all the fences that were here prior could stay unless you have to replace it or whatever, and then you're supposed to follow their rules.
Right. I mean, you can see how that's an aesthetic rule, and I would want to force them to try to tell me or prove exactly how it is that rule is for the health, safety, welfare, benefit of a residence, and or the to stop any abuse of the park.
Okay. Here's another one. New owners assume current rents of former tenants until the end of the year. Then park owners will charge much higher rents regardless of when lease was first signed. Is that legal?
So this is a terrible loophole in House Bill 1217. So House Bill 1217 did cap rent increases at 5% annually, except for one exception, which is if you are a new tenant assuming a lease upon that lease's renewal date. And that could be, say you assumed a lease and there was 3 months left, or there was 9 months left on it. It would be upon the renewal date that park owners can raise the rent any amount they want one time. However, there's a very big and important piece to that. They must have disclosed that to you in writing and letting you know what the rent would be going up to prior to you taking the home. So if they did not disclose that to you in documentation prior to you assuming the lease and taking possession of the home, then they would not be able to raise your rent more than the 5% in that certain scenario. They must have given you notice of that prior.
Okay, someone says, I understand rents are supposed to have been rolled back to $555, but I'm still being charged the $825. What can I do?
Well, there's no such provision in House Bill 1217 that rolled any rents back. The only scenario where rents were rolled would or could have been rolled back is if your park was involved in a corrective action with the Attorney General's office. If your park was involved in a corrective action where they improperly raised rents at some point, and the Attorney General's office investigated and deemed those improper rent increases, and in a corrective action told the park that they needed to roll back the rental amounts to anyone that affected, that's the only case where I know that rents would be rolled back. Unfortunately, when House Bill 1217 took effect, it wasn't until May 7th of 2025. And on that date, it was immediately affected. I know people that had their rent increase on May 1, and unfortunately, the House Bill 1217 did not cover them for an increase that year of more than 5%. They still got an increase of more than 5%, is what I mean to say. But anybody after, regardless of whether or not you received a increased notice prior to May 7th of 2025 that stated to be larger, the House Bill 1217 would have capped your rent anything after May 7th of 2025. So say you received a rent increase notice properly, which is key. You had to have received it properly to begin with, that said that your rent was going to raise to $800 from $600 in July. Then House Bill 1217 went into place on May 7th. They could not increase your rent from $600 to $1,800. They could only do 5% above the $600 at that point.
On top of that, if you feel like you've been misbilled, essentially that's what you think might have happened, I would go ahead and send a letter to the Attorney General's office with an explanation of why you think that that's incorrect and that your rent should have been rolled back, and start the process and let them work through it and find out if you were part of some settlement that included a rollback and it didn't happen, or if you just were on the wrong side of a date maybe, and so it wasn't eligible to be rolled back. But in order to give yourself peace of mind, I would go ahead and contact the Attorney General just to make sure.
Complaint.
Yes, and we have, if you go to our website, we have an instructional video on there of exactly how to do a complaint through the web portals. And certainly you can always call our 800 number and talk to one of us about, getting more information on how to do that if you need it.
Okay. I have a text here from somebody who I think's a paralegal, and it says, they appreciate, Michael, that you have experience, but they were looking for possibly a disclaimer suggesting this is not legal advice. And if an owner has specific questions, it's best to contact an attorney. And I know you said that at the beginning of the presentation, Michael, but we have had a few people who've joined since the start. So maybe.
Yes, if you joined late, you missed the disclaimer in the beginning. Most certainly, I am not an attorney. And as the disclaimer stated, that this is based on lived experience, and I'm not giving legal advice. I'm giving you information so that you can be informed and move forward on a process to protect yourself.
Okay, got another comment here from someone. This is a really good question. how would we know what the total water bill for the park is? Can we get that information from the public utilities?
You probably can't get it from the public utility, but you can ask the landlord for a copy of their bill, and they must give it to you. So, what we did was we asked them to give everyone in the park one from our tenants association. And as far as I know, everyone's still receiving one, so that you can actually figure out by division that they're not charging you 1 penny more than what the bill is, regardless of how they're figuring it out. That's the hard part. But you can ask for a copy and they need to give you one.
So, and this is not expressly stated in RCW 59.20. However, exactly what Deb is talking about is exactly what the state's attorney general's office has been enforcing as their interpretation of RCW 59.20, because an owner, can only charge you the actual pass-through amount. There must be accountability at some point as to what that actual pass-through amount is. And how could you get that other than to request it from the landlord? There'd be no other way to get it. So.
Okay, and I think I have one here that would be a really good one to pass along. This is great information. When can we anticipate another town hall? And are there any future other events we should know about?
Yeah, so well, we want to continue to do these town halls and these informative classes as much as we can.
Workshops.
Workshops, yeah, as much as we can, and get to these. There's so many subjects to go over, and so tonight we're just picking a few of the really big ones that constantly come up and are in calls that we have. But there's a lot of different subjects that affect us all as owners of homes within manufactured parks. And so we want to continue to work on this, and our plan is to try to do these at least quarterly if we can make sure that we can carve out the time to do it. That is our goal. As far as any upcoming events, we definitely will be having our annual meeting in Vancouver on September, what is it, you guys? September
26th.
26th. And we will be sending out a lot of information about that here soon. It'll go out via email. It's going to be on our website as the date gets closer. And I don't want to send stuff out too early, as that it has a chance to get buried and then people forget about it. So we want to make sure to send it out a couple of times, one with definitely about a month's at least advance notice. And then as we draw closer, a couple more times before the event actually occurs.
And I think that's everybody's question. So thank you, Michael.
Okay, well, so again, I want to thank everybody for taking the time to join us today. I've got to say, if you found value in this class at all, and you're not a member, please consider joining AMHO. Your $15 membership donation goes a long way toward allowing us to continue this type of session and more. If you're already a member, thank you very much. I also want everybody to know that you can now visit our website at wamho.org to both sign up for a new membership and renew your existing membership through the website. Okay. You can also find all of our contact information on the website as well. Everybody that you see up here that's in a photo is a board member, and our information is readily available on the website. So I'll say good night to everybody, and remember, work together, know your rights, and be empowered to protect them.
Michael, would you give them the 800 number? Do you have it in front of you that you could tell them what it is?
If you give me just a second, I can.
I'd like to give Michael credit for getting a phone number 877 RCW 59.20.
That's
That was
Exactly.
awesome.
I was able to find that, and very surprised that it was available. But let me give you the actual numbers as well, because nobody looks at the letters on their phone anymore when they're dialing, right? So it is 877, as Tina said, RCW 5920, or 877-729-5920. All right. Again, thanks you to everybody for coming, and we'll go ahead and sign off now.
Thank you, everyone. Good night.
Thank you for showing up. We really appreciate your listening.